Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by Livelaw, your one-step destination to all legal developments in the country. Let us start. Starting with the update on the Delhi liquor policy case. This issue has been the center of attention for a long time now. Senior leaders of the Aam Aadmi Party, namely Manish Sisodia, Sanjay Singh, have been in judicial custody regarding this matter. BRS leader K. Kavitha and Delhi Chief Minister Arvind Kejriwal were arrested this month in the same case. Kavitha was today produced before the special CBI judge Kaveri Baveja on the expiry of her ED remand. Today, ED requested that Kavitha be sent to judicial custody, which the court allowed and remanded her to judicial custody till 9th April. The agency has alleged that Kavitha, along with other members of the South Group, conspired with the top Aam Aadmi Party leaders and gave them kickbacks to the tune of 100 crore and in exchange got undue favors in the formulation and implementation of the excise policy. In the same matter, you know that Delhi Chief Minister Arvind Kejriwal had skipped 9 summons issued to him by the Enforcement Directorate. He was arrested by the ED hours after a division bench of the Delhi High Court refused to grant him interim protection from coercive action. Following his arrest, though Kejriwal had promptly moved an urgent petition before the Supreme Court challenging his arrest by ED, it was later withdrawn. Also last week, the trial court had remanded Kejriwal to ED custody till 28th of March. The Delhi High Court is set to hear his plea challenging the arrest by Enforcement Directorate and 6 days of remand tomorrow. The matter will be heard tomorrow by Justice Swarnakant Sharma. Stay tuned with Livelaw for further information. The Delhi High Court has restrained a food outlet from using the Wow Punjabi mark after the famous eatery Wow MOMO sued it over trademark infringement. Wow MOMO Foods Private Limited filed a lawsuit claiming that its main brand name is Wow and it is a crucial part of all its trademarks like Wow MOMO, Wow Chinese, etc. They argued that Wow Punjabi, the defendant outlet, copied their key trademark and its overall appearance. They also said that they had sent a cease and desist notice to the defendant to stop using their trademark, followed by a legal notice, but got no response. Justice Anish Dayal said that Wow MOMO made out a prima facie case for grant of an ex parte ad interim injunction in its favor and that it is likely to suffer irreparable harm in case the relief is not granted. Accordingly, till the next date of hearing, an ex parte ad interim injunction was passed against the defendant. The Karnataka High Court has refused to quash a defamation complaint filed by Kannada actor Sudeep S. against N.M. Suresh, who is the office bearer of the Kannada Film Producers Association and secretary of the Film Chamber of Commerce, for allegedly making false accusations against Sudeep. The actor had submitted specific allegations against 2 accused with regard to the statements made by them defaming him. It was alleged that the accused in a press conference made statements against the actor which were defamatory in nature. He submitted that it had affected his standing and reputation in the society. Thereafter, it is stated that the accused also published messages in social media and that they held protests against him. One of the accused, N.M. Suresh, who is the office bearer of Kannada Film Producers Association, approached the Karnataka High Court seeking to quash the proceedings pending before the trial court for defamation. But a single judge bench of Justice S. Vishwajit Shetty dismissed his petition. The court said that the trial court, having found that complainant had made out a prima facie case to proceed against the accused persons, had issued summons. And after receipt of summons, Suresh had appeared before the trial court and was enlarged on bail. Accordingly, it held that no illegality or irregularity was found in the order of the issuing summons by the trial judge, and the court dismissed the plea. The Rajasthan High Court has observed that if 2 adults willingly engage in sexual relations outside of marriage, no statutory offence gets constituted. In this case, an FIR was filed by the husband alleging that his wife was abducted by certain individuals. but the court dismissed the FIR after the wife herself appeared in court and submitted an affidavit stating that she had not been abducted but was in a voluntary live-in relationship with one of the accused. Given that the victim herself declared in court that she had not been forcibly taken away, the High Court concluded that no offence of abduction under IPC was established, and so the FIR was quashed. Then, the husband argued that since his wife had admitted to being in an extramarital relationship, which is similar to adultery, thus the offence of adultery under Section 497 of IPC and of bigamy under Section 494 were established. But the court dismissed the husband's petition. Justice Birendra Kumar stated that according to Section 494, the offence of bigamy only occurs when someone enters into a marriage with another person while their spouse from a previous marriage is still alive. The bench clarified that relationships resembling marriage, such as live-in relationships, would not be considered bigamy unless one of the partners enters into a legal marriage. The court also observed that adultery under Section 497 of IPC has already been struck down by the Apex Court in the case of Joseph Shrine versus Union of India in 2019. The Telangana High Court has taken up a public interest litigation initiated by a 6th grade student from Joseph Public School. The student wrote a letter to the court requesting the relocation of a bar located in a residential colony due to the nuisance it creates. Chief Justice Alok Aradhe addressed the matter and brought it before a division bench including Justice Anil Kumar Jukanti. In her letter, the student had expressed concerns about the bar being situated in the middle of their colony, close to several schools and a new Lord Shiva temple. She noted that the bar's loud music late at night disturbs nearby residents, particularly the elderly living in nearby old age homes. She also highlighted safety concerns for children attending evening coaching classes and elders who refrain from evening strolls due to the bar's atmosphere. The PIL requested the court to direct relocation of the bar to an area less densely populated by residential buildings and educational institutions. The Madras High Court has ordered recounting of 605 postal ballot votes which were rejected without assigning proper reasons in the Krishnagiri constituency during the 2021 Tamil Nadu Legislative Assembly elections. Through an application, the DMK candidate T. Senguttavan had challenged the rejection of 605 postal ballot votes which resulted in the victory of the AIA-DMK candidate. It was argued that there were discrepancies and irregularities in the manner in which the returning officer had improperly rejected the postal ballot votes. The court relied on the judgment of the Apex Court in Arikala Narasa Reddy, where the Supreme Court had laid down the conditions for recounting. The High Court, upon perusing the documents, submitted that it was convinced that the rejection of the postal ballot had a bearing on the ultimate result of the election. The court noted that the winner had won by a slender margin of 794 votes, and thus if it was proved that the rules were not followed during the rejection, the same would have an impact on the outcome. Therefore, Justice P.T. Asha directed the Registrar General of the Madras High Court to name any of the registrars to supervise the counting of the postal ballot votes and submit a report on the reasons recorded for rejecting the postal ballot votes, whether reasons were recorded on each postal ballot, and whether the number of votes rejected under each head detailed in Form 20 tallied with the number of votes rejected under the respective heads. Rajasthan High Court has refused to issue directions for the live streaming of court proceedings and has rejected a public interest litigation filed seeking issuance and directions for the same. The division bench of Chief Justice Manindra Mohan Srivastava and Justice Bhuvan Goyal dismissed the PIL and stated that video conferencing facilities are already available to all the litigants and that the facility of live streaming could not be granted as of now. Let me tell you, several high courts, including those in Calcutta, Guwahati, Meghalaya, Gujarat and Madhya Pradesh, have begun live streaming court proceedings in recent years. Many others have also introduced rules for live streaming and recording proceedings to establish the necessary infrastructure and framework. The Calcutta High Court, however, has raised concerns about the misuse of live streaming facilities originally implemented to ensure fairness and transparency. In a landmark decision in 2018, the Supreme Court had ruled in favor of allowing public access to its hearings through live streaming, considering it a fundamental aspect of access to justice. In 2002, the Supreme Court took a historic step by live streaming hearings before constitution benches, garnering significant public attention, with numerous viewers turning in to watch the proceedings. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Livelaw. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos, or consider becoming a member at just 89 rupees per month.